Hi, everybody. I hope you're having a good afternoon. I have about, I think, like 2 weeks left until I take the bar. So I'm really cracking down on studying. And right now I am reviewing my crim law flashcards. So I'm going to go ahead and get started. Okay. My first flashcard, which I did just have pulled up. Where did it go? Okay. All right, so my first flashcard. What is common law murder? Okay. Law murder is killing human being killing another human being. It's funny that you have to say like living human being because one of the requirements is that the person that you kill isn't dead, which I think is very interesting, but that's how the law works. It's very, very specific. Okay. With malice aforethought. And the mental state is malice with malice. And there's a few different ways you can have malice. You can have reckless disregard for like safety. You can have the actual intent to kill, and then you can have the intent to like do serious bodily harm. Those all three count as malice. And this is common law murder because this is common law is law that, well, it comes from like England, but it arises out of um well, yeah, it like arises most commonly out of case law. So we have the common law, but we also have more modern laws now, and some states still use common law, and some states have adopted the newer laws. Okay, I should include that this is the unlawful killing. So if you have authority to kill the person, then it's not homicide. Oh, what four states qualify as malice aforethought? Oh, I always forget this one. Okay. So malice can be intent to kill, um, intent to cause, I think it's grave or yeah, like serious bodily injury, reckless disregard of life. And this is the one I forgot, so I'm going to write it in capital letters. Intent to commit. So this is where intent to commit a felony. And then maybe you've heard of like felony murder cases where it's like if you are committing a felony and someone dies like while you're committing it, that's going to count as malice. And that's what felony murder is. Just someone dying in the process of committing a felony. So I missed one when I said that earlier. So it's intent to kill, intent to cause bodily harm, reckless disregard, or committing intent to commit a felony. Okay, those are all considered malice. What are the 5 most common inherently dangerous felonies that could give rise to a felony murder charge? It's a battery, assault, rape and kidnapping, and robbery. I just forgot robbery. Okay. Most likely, well, sorry, let me make sure I have this right. This is, okay. Battery, assault, attempt. Oh, I was talking about too fast. It's arson. That makes sense because someone might die if you are committing arson. Robbery, which is like stealing something with force. Rape, kidnapping. Okay. And they like come up with all these like funny little acronyms. This one is BARK with 2 R's, which actually is how I remembered it, but I didn't remember the robbery R. I only remembered 1 R. Okay. So the 5 most inherently dangerous felonies that are likely to lead to, well, that are more likely to lead to felony murder is battery, arson, robbery, rape, and kidnapping. Okay. What is the usual definition of first-degree murder? It's deliberate and premeditated, or it's felony murder. Okay. So first-degree murder. And this is different from common law murder because this is like by statute, meaning like a state has passed a law that says like in this state, this is what a murderer is like. If they don't pass a law, then they're just defaulting to the common law murder. But most states have passed these definitions. Okay, not by statute, no murderer statues here. Statute. Hey, Olaf, it's good to see you. That was fun with Andy earlier. Okay, and it is by statute. Usually it is deliberate and premeditated, or felony murder, meaning someone died while you were committing the felony. What is voluntary manslaughter? Voluntary manslaughter is homicide with malice, but there's mitigating circumstances that make it a little bit less bad than murder. Okay, oops. I don't know what I did. Let me go back. Okay, so in common law, you have your common law murder, voluntary manslaughter, homicide. Well, I'll just put this. I think I'll just put homicide. Homicide. I just go back and forth between whether I should put homicide or murder, but I think it's technically just homicide. Homicide with malice, forethought, but with mitigating circumstances. And when I talk about mitigating circumstances, it just means circumstances that might make it like more reasonable that you killed this person. So like one example is a heat of passion. I feel like this is so old school. I don't know why. I mean, I don't know why this is still a thing. But like traditionally, like if a man came home and found another man like in bed with his wife and killed like that man, the heat of his passion of his heart would be like a defense. So he might not actually get murder, but he might be able to get down to voluntary manslaughter because like he couldn't handle his passion. That's like the very, very traditional use of it. And another, well, that's probably the most common one. Murder equals bad, Olaf. Yeah. Yeah. One of the things that I learned in law school, except there's not a lot of people who like follow like YouTube true crime things, but I feel like the people who I don't know. I don't really follow murder cases, so I would never say I'm a self-learned serial killer expert, but those type of people, I don't know how they can like handle sleeping at night after watching some of like the crimes and stuff. Like the Idaho 4 case, I could not watch. That was like too scary, too gory for me. Karen Reed I could watch, but that was like the murder was barely mentioned. Well, the alleged murder was like barely mentioned in it. Okay, so I've done common law murder, voluntary manslaughter, first degree. Okie dokie. What is involuntary manslaughter? That is unintentional homicide with either negligence or recklessness during an unlawful act. Okay. So involuntary manslaughter, homicide with negligence, common law, or recklessness under the model that's it, during an unlawful act. Okay, and I was talking about like how we have common law and then we have a set of rules. Those rules for criminal law are called the model penal code. I always laugh when I say penal, the model penal code. And most states have adopted that, but some states haven't, so we have to know both. Okay. What are the 3 common law categories of homicide? I don't think I knew that. All right, that's a good flashcard then. Let me start a new one. 3 types of common law murder. Justified by law, criminal, and excusable. I swear I have not heard that. Homicide, justified by law. Criminal homicide, excusable homicide. I want to know what an excusable homicide is. Okay. What type of causation do you have to prove? Well, it's kind of the same for everything, but so I hate causation in cases. It's one of my least favorite things because not only do you have to prove that you suffered like an injury, but you have to prove that the other person's actions caused the injury. And causation can get so messy because you can imagine like the other side can come up with a million different things that might have caused it or tried to get out of it. So, but there's 2 types of causation, and this goes for mostly like any crime and like in civil court too. There's 2 different types of causation, like the actual cause and the proximate cause. And so you have the actual and proximate. So you have to, okay. So the actual cause is, if not for the conduct, person wouldn't have died. And the proximate cause means it was foreseeable results of your actions, basically. Foreseeable, that's natural, and probable results. What kind of adequate provocation may reduce a murder charge to voluntary manslaughter? Well, the heat of the passion, something that can inflame the passion of someone. That's so crazy to me. Sorry, I'm reading my note cards out loud and thinking at the same time. It's just so crazy to me that it says like a discovery of adultery by a spouse constitutes adequate provocation for like murder. That's so crazy. Why is that okay? I mean, that's wild. You would think that would change by now. I don't know. But okay. Ways to reduce murder. to manslaughter. Heat of the passion. So situation, I think it's like inflame the passion of a reasonable person. Yeah. Where it could momentarily cause them to act out. I don't know if any of you can think of any situations that inflame passion enough to murder someone, but there you go. Basically enough to murder. Out of, what do they call it? Passion. Okay. And then the two, yeah, serious battery, threat, or actual deathly force. And crazy, discovered adultery of a spouse. Cray cray. When should I consider the degrees of murder if it's statutory? Yeah. Degrees of murder do not exist at common law. So anytime you hear someone say first degree or second degree murder, they're talking about a state where they have passed laws that define murder. If you just hear someone just say like murder, usually that means that they don't follow the modern law and they follow the common law. Got it. When is murder reduced to voluntary manslaughter due to imperfect defense? What does that mean? Hold on. I think I made a mistake. Did I miss? Yes, this should be raised to reduce to involuntary manslaughter. So involuntary manslaughter is the one where you could be overcome with heat of passion or whatever. Okay, ways to reduce murder to voluntary manslaughter. Oops. If the other person started the altercation, why don't they just say self-defense? Sometimes I hate how lawyers write. Okay. Alrighty. In what two circumstances can a killing give rise to a charge of involuntary manslaughter? A killing that happens when you're committing a misdemeanor and a killing, yeah, that happens when you are committing a felony. Sorry, I'm thinking about where I want to put that. I think I'm going to put that on this slide. Someone killed while committing a misdemeanor or a felony. Okay. Hey, Ola. If it's heat of the passion, how do they decide that it should be reduced to manslaughter and not NGRI? Ooh, what is, let me look up NGR. What is NGRI? Oh, not guilty by reason of insanity. Yeah. So insanity it requires you to not know the nature and consequences of what you're doing. And I think they probably think you're doing it because you're mad, so you know what you're doing, if that makes sense. But when you are claiming insanity, you either like, there's different tests for it, but you either like aren't able to tell the difference between right is wrong, or like you truly believe what you're doing is right, or like you're not aware of what the consequences are, or like that it's a violent or like a deadly action. But for a heat of the passion, because you're overcome with emotion, you're like conscious and aware of what's going on. Yeah, let me know if that made sense. That was a good question. What are the 6 elements of larceny? I love the word larceny. It's just so fun to say. Common law larceny. Well, it's taking or carrying away something that belongs to somebody else with the intent to deprive them permanently of it. Yes, yes. Without consent. I always forget that part. So 1, taking or, well, trespassing, which just means like doing something without consent. Because you can trespass on land, you can also trespass on a thing, and that's when you like borrow something that doesn't belong to you. But anyway, so you have to trespass or do this without consent. You have to take or carry away. 3, personal property. 4, of another, with the intent to permanently deprive. What did I miss? What did I miss? Trespassing, taking or carrying away personal property of another with intent to permanently deprive. What am I missing? It says there's 6. Oh, okay. They separated take and carrying away. Okay. So common law larceny. Yeah, I already knew that. Taking something that belongs to someone else without consent, with the intent to permanently deprive them of that thing. Okay. And this is specific intent. So some laws, some crimes, you just have to have like the intent of doing the action. And then other crimes, you have to have a very specific intent. And this is one. So like if you were intending to return whatever you took, it wouldn't be considered larceny. So if you could make it, like if you stole something and you could make the claim and like, show that you were going to return it, you could get another charge, but it wouldn't be larceny. Larceny requires like the mental state of intending to like keep that thing forever. Hola. I have a video about a lady that tried to kill her children and was determined not guilty by reason of insanity. She started a YouTube channel while in the halfway house. She's basically a total lolcow. Oh my God. I can't believe she started a YouTube channel. She ended up getting herself locked away forever in the end. I never agree that she should be NGRI in the first place. I think she knew what she was doing. Wow, that is so crazy. I can't believe she got a YouTube channel. I wonder how she ended up getting locked, like why she ended up back in jail. That's so crazy. What did she even talk about on her YouTube channel? No. That's weird. Larceny does sound fancy. It does sound really fancy. Okay. What two elements do you add to larceny to turn it into robbery? It has to be by force. It has to be attached to the person. Yeah. So, larceny plus force and victim present equals robbery. Okay. So robbery requires force and the victim present. Larceny, you can do it without anybody seeing you. What are the 4 elements of common law arson? Intending, well, you intend to burn something with malice. It's a home, and it's not your home, I think. Let me check. All right, good job. Yeah, okay. So arson, this is common law arson, because the newer definition of arson doesn't have to be a house. You don't have to intend to like actually burn. But anyway, this is common law arson. Requires malice, burning someone else's dwelling. Yeah. I'm just going to do this. Malicious burning of someone else's dwelling. So if it's not a house, it's not common law arson. And if it's your house that you burn down, it's also not common law arson. But that changes depending on the state you're in. And, oh no, I did not mean to do that. What did I do? Where did it go? Okay. What are the 6 common law elements of burglary? Okay. Pretty sure it has to be at night. You have to enter someone else's home with the intent to commit a felony. Let's see what else. Yeah, I don't know why. Sorry, I keep talking to myself, but I get really annoyed when like the flashcards or like the books I'm using don't work like my brain. But yes, good job. I got it. They just said it weird. Okay. Hey, Andy. Yeah, it had to be at night. Now the more modern version of burglary doesn't have to be at night. Well, and then I forget what the other difference is. That might be the only difference. But yeah, common law, it has to be. Okay. Common law burglary is breaking, entering, yeah, someone's dwelling at night with the intent to commit a felony. So it doesn't have to even be to steal something. I can't think of what. Well, it could be to, I guess, like kill somebody. But it just has to be the intent to commit a felony inside the house. That's important. Okay. And this one is another specific intent. You have to specifically intend to commit a felony. So if you can convince them that you were intending to commit a misdemeanor, you might be able to get away without burglary. And I don't know when night starts. I guess when sundown. Okay. What is the main difference between larceny by trick and larceny by false pretenses? I don't know. Okay. All right. So let me put this here. Larceny by trick. Yeah, Olaf, that's such a lawyer question. And I guarantee you lawyers fight about that. I'm positive lawyers fight about when night is. That's a very lawyer question. And yeah, I 100% imagine that gets argued a lot. Larceny by trick is you tricked them to give you, no, sorry, it doesn't go there. That's robbery. So it's robbery. Okay, larceny by trick, you tricked them to get possession. And then false pretenses is when you like falsely misrepresent that you are the owner. Yeah. Pretenses, fraudulently become the owner. Andy, is that still current law? And so in common law states, yes. But most states have adopted the modern statutes where it doesn't have to be at night. I wonder what states do follow. Common law, what was it? Burglary? Yeah. Oh, there's no state. See, this is the other reason I don't like law school is because they make us learn a bunch of shit that doesn't show up anymore. But why are you teaching us this? Anyway, no US state actually uses that definition of common law burglary. Yeah, most have changed it so it takes out the nighttime. It doesn't have to be a home or like a dwelling. It can be other places. And you don't have to actually break walking in. If like doors open, that counts too. So yeah, no one follows that anymore. Then why make us learn it? Why? Why? I know, isn't that crazy, Andy? So I guess if you're breaking and entering in like during around lunchtime, then it's not burglary, or wasn't at least. Okay. My next one. What are the 3 elements of the crime of receiving stolen goods? Don't remember that. Okay. Receiving stolen goods, you have to get possession, you have to know that it's stolen property, and you have to intend to keep it, I think. Yeah. Get the goods, know they are stolen, intend to deprive permanently. So this would be another specific intent crime, because if you only intend to borrow it, then that's different. Okay, next, common law battery. It's intending to make offensive contact with someone's person. Maybe you cause harm. Yeah. I kind of said it funky. Unlawful force against another person. That causes harm or is offensive? Well, they say is an offensive touching. Okay. What an offensive touching is, well, I think that's probably a lot of different things. And you don't have to intend the touching to be offensive. It's just if it is offensive. You just have to intend to touch them. Which means it's a general, I'll write that down. It's general intent crime, meaning you don't have to, all you have to do is intend to make the contact. Olaf, only rob houses in the daytime. Pro tip right there. Pro tip. This is my question all the time. Why do I need to learn erroneous history? There's so much to remember already. Like, don't make me remember the things that I'm never going to use. What are the 5 elements of embezzlement? You have, I think you have to have access to funds by consent. And then but you transfer ownership. I should look at it. Yeah. Fraudulent conversion of the property of another. Okay. Alrighty. So embezzlement. Offensive touching, I know. Yeah, like even getting spit on is battery. Yeah. Okay. Sorry. Embezzlement. That's another one I like. I like larceny and I like embezzlement. Those are both fun ones to say. And embezzlement just sounds cute. Like it just sounds, I don't know, like nuzzling or something. Embezzlement. But it's not very cute. Having property by consent. Unlawfully converting ownership of someone else's property by, okay, when the property was given by consent. So an example of this would be if you, let's say, theoretically were to do a fundraiser where people gave you their money for a specific purpose, and if by somehow you converted ownership of their money that was supposed to go to the charity to become your money, that would be embezzlement. Just in theory, though, just in theory. All up. Only enter a house to borrow things before nautical twilight. I love that. Andy, I think you should write the new law. I think you'd be actually an amazing judge. If I were to read an opinion that had that like very good advice in it, I'd like that. So judges do get very flowery with their words, especially the Old English ones, which I'm sure you know about, Andy. Who was it who said they were, was it someone who said Turtle Boy was like Holmes? Was that you, Andy? Did you read that? I thought that was so funny. If you don't know what I'm talking about, Andy, let me know. What are the 2 types of criminal assault, and are they general or specific? They are, well, the 2 types of assault are assault where you intend to cause fear, and then attempt to commit battery. So battery is when you're actually touching somebody. So if you don't make it to touching, but you try to offensively touch them, that is assault. But for intent, let me look. All right, I was right. Yay. Okay. Isn't that like an old, maybe is that an old English judge? Am I making that up? Maybe not. Maybe he was an American judge. Yes, I think he was. Anyway, I was on some stream and they said that Turtle Boy is like Oliver Wendell Holmes Jr., who is an old judge. Oh, he was deeply immersed in English common law. Do you know him, Andy? Yeah, let me put what's his name? Oliver Wendell Holmes Jr. Yeah, he has some quote about justice, and I guess Turtle Boy said something very similar. And like the Turtle Boy gang, they were like, "Oh my gosh, he's like Oliver Wendell Holmes Jr." Um, yeah, but I guess he was an American judge, but he was in English common law a lot. Okay, what are the two types of criminal assault? Thank you, Andy. He's a Scottish justice. My knowledge of the Supreme Court is so bad, so bad. I think I can name all the justices now. When I started law school, I might not have been able to. Hold up, assault, spitting on the police like Letitia Collins did, and getting her ass locked up for a long time. Is that what she? Oh my gosh, she's crazy. I've heard. Wait, is that the same person as Letitia Stout, or is that different? A lot. Yeah, it is very true. SCOTUS is really. Uh, I mean, is there a SCOTUS anymore? Barely. Um, I'm sorry, I got distracted. My criminal assault is either attempt a battery, and that's going to be general intent crime. So you're attempting to touch them, but you don't. That's criminal assault. And then if you intentionally put another in fear of imminent harm, that is a specific intent crime. So if you scare somebody, but you didn't mean to scare them, then it's not assault. You have to actually intend to put them in fear that they'll get hurt. And it has to be imminent. So you can't like tell someone I'm going to come back here with like a gun a couple hours later and hurt you. That won't count as assault. But if you say like, I got my gun and you pull it out right then, that's assault. Different Letitia. Do we know any good Letitias? Because the Letitias I've heard of so far, I'm not liking. I don't like that there's two crazy Letitias. What are the 4 elements of kidnapping? I don't know why I'm trying to blank. Unlawful confinement. Yeah. Okie dokie. So kidnapping, it's a little bit like false imprisonment. Unlawful, I think it's, yeah, confinement of someone without consent, and moving or hiding them. Yeah, false imprisonment doesn't, it just requires you to confine them, not move them. I don't know any of the good Letitias, actually. Can we get a good Letitia, please? Please? Okay. I hate this one. What are the 4 common law elements of rape? I hate that we have to learn about this. And I hate that it's on our exams, but I get it. Okay. Hi, Tina. Oh, it's good to see you over here. Oh, I'm so excited you found me. Okay. Well, common law rape is with a woman. It's unlawful sexual intercourse with the woman by force. Is that right? Yeah. When I took my criminal law exam for law school, my first year, oh my gosh, there was so many violent crimes on there. It was so hard to get through that. Like I did not do well in that exam because it was like so hard to get through. Because it was literally like she wanted to make it as complicated as possible. So she put all these crazy crimes. So like everyone's assaulting everyone, everyone's murdering each other. Like it was crazy. Like I remember coming out of that exam and it's like 4 hours of just like reading like horror stories. I think we got like one burglary question. That's crazy. Unlawful sexual intercourse with a woman by force, or I think, do threats count? Yes. Threat of immediate force. Okay. When is consent by fraud a defense? And when is it not a defense? Maybe if they were, I don't know exactly what they're talking about. Because it's never a defense with its age. I'm sorry, I'm very confused about what they're asking me. Hold on, I gotta Google this. I don't know what this means. Oh. Okay, got it. Yours was like that too, Andy, your crim law exam? I'm like, ma'am, this is not a scenario, right? So many of the scenarios aren't. That makes me feel better that yours was like that too. Yeah, I'm so happy to have you here too, Tina. It's fun to just talk out loud, and it definitely is helping me with studying. Yes, and yes, an affirmative defense. There are two types of consent. So consent by inducement. So lying to have intercourse, basically. Not a defense, right? But if you're lying that you're going to have intercourse about the act, wait, I think it might be the other way around. I'm getting myself confused. I've been studying for so long. I feel like everything is turning to mush. Where did you go? Yeah. Oh, it's the other way around. Okay. Yes, that makes sense. That makes sense. Okay. Well, it doesn't make sense, but it's a defense. Consent. What's it called? De factum. Consent by fraud in factum. Lying about the act of intercourse is not a defense. Okay. Can we be done with these flashcards with this set? I don't want to do any more rape. Statutory rape is whatever under the age that the state sets. Strict liability, there's no way to get out of it. If you did it, even if you didn't know, you're still responsible for it. Okay. And that's why it's called statutory rape, because it is by a statute or a law. Yay, perjury. Okay. Okay, perjury is what is the actual? Well, I know what it is, obviously. Oh, like giving false testimonial statements. Yeah. Well, they said it a little differently. Perjury is, they say, yeah. I think that's it. I mean, willfully taking an oath and sorry. Falsely promising to tell the truth. That's what it is. In writing or verbally, about material matters that would affect the outcome of the case. Okay, so what's the definition? It is because it's not the telling lies, it's the falsely promising to tell the truth about material matters that would affect the outcome of the case, and it can be in writing or oral. Okay. Tina, it amazes me how much information lawyers, judges, and paralegals can pack into their brains. It is so crazy how much information. And that's really all it is. Like, if you are willing to like put in hours and hours and hours of just like memorizing things, like you can be a lawyer. It's just so much, so much. And it's hard in classes because in law school, at least your first year, the only grade you get is your final exam. So, I mean, there's like check-ins, you can meet with the professor, you do practice tests and stuff throughout the year, but like you're really just banking on like having the memorization down by the end of the year. Right. My next one is bribery under the common law and under modern law. Okay. Bribery. Um, Corrupt payment to influence an official. Okay, I'm gonna look. A misdemeanor involving corrupt payment to influence action of an individual. That's what misdemeanor on. Of offering something of value corruptly to an official to influence the carrying out of their duties. Modern law, it can be a felony and people who are not public officials. Okay, so this is bribery, common law. Bribery, modern law, felony. Doesn't have to be, well, felony offering corrupt payments or something of value to a public official or other person to influence their duties. And I think the person doesn't have to accept it. Yes. Okay. Don't have to Would perjury only be a crime if a, yes, you're exactly right. If, sorry, would perjury only be a crime if a person is under oath? Yes, that's exactly right. That's what makes it a crime. Because when you're giving your oath, you're promising to tell the truth. And so like everything you say has to be the truth after that. If you say the false statements like before you swear in, then it's not perjury. It only applies when they're like when it's under oath. Hi, Andy. Is common law in the US history and US law schools? UK, there's common law, case law, and statutory law. Yes, yeah, exactly. It's the same in the states too. We have common law, case law, and yeah, the statutory law. Um, oh, remedies reside in common law and in equity. Um, do I would say probably the remedies do still, I think it's the same. I would say remedies still reside in common law. Um, but for some states, like some states, I don't know if it like what does the UK have states? I don't know how they divide up things, but like certain jurisdictions will rely on common law and some jurisdictions rely on like the proposed model law that whatever organization like cooked up. I don't know if the UK does that, where different places use different ones. Late for class, again, that darn chinchilla. So funny. I was telling CH yesterday about I used to teach kindergarten, and one of my students came in and said that their chinchilla ate their homework. Like their mom called me and she was like they weren't making it up. Our chinchilla really did eat the homework. I always think that's a really funny excuse. Okay. What do I have next? Let me see. Oh, sorry, I was looking at my phone for something. Okay. My next. What are the three elements of common law solicitation? Um, you have to request someone to do something. That's a crime. And you have to ask them with the intent that they actually do it. Like, yes. Common law solicitation. Encourage, request, demand someone to commit a crime and intend for them to commit it. Okay. I'll be right back, guys. I have to go grab some water, so I'll be back in just like a couple minutes, maybe less than that. Okay. I need to figure out how to put on wait music or something Okay, I am back. Thanks for waiting for me. I got back. Can you hear me? Am I on? I think I'm unmuted. I can't tell. Oh yeah, I am. Okay. I'm on my law school right now, because I don't have AC, but they like crank up the AC in the law school. And over the summer, there's not that many people here. So I got kind of used to like having this entire floor by myself. And I just got really freaked out. But it was just another student. Like I knew him. Like he came up behind me. He was just like, hey, and he like scared me at the water fountain. Um, yeah, professors don't like coming in over the summer, but they don't have to. But it's been really nice having, because I live near my law school, so and it's not even my law school anymore, but they still let us come here since we're studying for the bar, which is nice. But I've been like taking naps here and stuff because it's been so hot. It's crazy. Under modern law, what inchoate crimes merge? Okay. Where did my window go? Okay. All right, so they're asking about inchoate crimes. Inchoate crimes are crimes that don't get completed. So they're things like conspiracy, because you can be charged for conspiracy even if you don't actually do the thing. Attempt, because you can get charged with attempt even if you don't actually do the thing. Anyway, so they're asking when do well inchoate crimes merger? I'll just write this down and then I'll explain it. So conspiracy does not merge. Attempt merges. Solicitation merges? Yeah. Okay. So when they talk about merging, like let's say you successfully steal something, you can't be charged with like attempt to steal and stealing. So your attempt to steal would merge into the final crime, which is just stealing. But other crimes can be different. So attempt and solicitation. So asking somebody to do the crime for you, if it actually happens, it merges into the final crime. So you would never be charged with attempted battery and battery. And you would never be like charged for like solicitation for to commit battery and actual battery. You would just get charged with the final thing. But the only one that's different is conspiracy. Conspiracy does not merge. You can be charged with conspiracy to do whatever, and then the actual crime itself does not merge. Oh, you're having a heat wave too? I know, I thought we were done. I was so thought we were done. Hi, Andy. Oh, sorry. No, hi, Andy, and hi, Tina. Appeal not guilty. Oh, in the US, you cannot appeal not guilty. But that's interesting that you can in the UK. Or Andy, that's so smart. I can't read that because I don't know what those things mean, but that's so smart to do international law, especially right now. I'd love if I was in international law. Law is about to become real difficult for new lawyers and everyone. Even like the professors at my law school, they like they're like, this is the law right now, but does it really mean anything anymore? So, which isn't great. I think right after Trump got elected, I was like, yeah, after Trump got elected, I was like asking my career office, like, do you know how I can get into Canada? Like, can I learn Canadian law? I was really like, I don't want to do this US law anymore. Okay, got that. Yeah, okay. What are the two elements of a criminal attempt? You have to take a substantial step to do the act, and you have to have the specific intent to commit the crime. Attempt requires substantial step towards committing the crime. And the specific intent of that crime. Oh, JK, that's not true. Intent to commit the crime. Okay. When is impossibility a defense? When is abandonment a defense? I don't actually think I remember this. Let's see. What? I don't know what this means. Okay. Defenses. If it's not a crime, then can't be charged with attempt. I guess that makes sense, because then you would just get charged with attempting anything, I suppose. Maybe, I don't know. Well, the law is so weird and redundant, and they say everything the same way like 100 times. No, I think I just logged myself out of my flashcards. Sorry, I'm somehow X'd out of my flashcards and I'm going back. There we go. And we were on. Okay. Okay. Abandonment. Okay. If it's not, so this is impossible, legal impossibility. And abandonment. I think it's still a defense until you have done the act. Is that right? Yeah. So probably until you take the substantial step. Okay. So you can say, I was going to do it, but I abandoned it. Tina, yes, the law is so redundant. Is it intentional so as to confuse people? 1,000, 1,000,000%. So many of my professors have said, like, oh, if judges didn't write like that, like lawyers wouldn't have a job. And there's like a new modern trend where like lawyers are being taught to write much more directly. But yeah, when you like listen to what judges say or like the ways that laws are written, yes, it's 100% meant to be confusing. 100%. Yeah, because there's always an easier way to translate it. I don't know. It's like an elitist thing, I think. Like lawyers just want to sound fancy, and they're afraid that like people will realize, oh, anyone can be a lawyer as long as you like spend the time reading. That's literally all it is. Yeah. Okay, thank you guys so much for hanging out with me. I'm gonna take a break. This was actually really good because I didn't know some of these things, so I need to review. I probably won't be back on tonight, but I'll definitely be back on tomorrow. I hope you guys have a good rest of your day, and thanks for hanging out with me. Like, this is good. I really did need supervision, so I'm glad you guys were here. I'm sure I'll see you in a different chat later today. Have a good rest of your day, guys. Bye.